Welcome to this program on mortgage rights and remedies in 1981. Your two co-chairmen are Mr. Philip Spencer and Mr. Wayne Gray. They've worked long and hard with a very hard-working supporting cast in putting this program together and in having prepared the papers which you have in the book which is in your hands. Very briefly, let me give you a bit of biography. Philip Spencer came into law through York University, Osgoode Hall Law School. Practiced since his admission in 1969 with the firm of Spencer Stewart, Thompson Spencer Stewart, and more recently, where he now is a partner in Staples and Sewell. He is taught in the Bar Admission course. He is a contributing author to Families in Canada 1979 and is a member of the Board of Directors of the Credit Counseling Service of Metropolitan Toronto. His work is in commercial contract, construction litigation, general counsel work, and his work includes all forms of mortgage remedies and mortgage problems. Wayne Gray also practices with the firm of Staples Sewell, and Wayne came into law through the University of Windsor Law School, called to the bar in 1978, joined the Staples Sewell's firm at that time, and his practice is devoted to mainly to the field of mortgages and mortgage remedies. Now I'm going to leave you in the good hands of your two chairmen, and we have a busy day. We'll try to stay with the timetable, and I'll make one little break at the end of the first lecture, which I'll announce at that time.
Thank you very much, George. Well, good morning, and thank you all for enrolling and coming, and thank you for coming here so promptly. You have the program, and I just wanted to tell you what we were going to try to accomplish today to make it as useful and interesting as possible, because some of the topics that our speakers have are not exactly interesting dynamite to listen to. However, they are useful. Now, firstly, looking at the schedule, there is one rearrangement. What is number 6 on your schedule, that is other proceedings during the notice period, will be dealt with at about 9:50 a.m. by Bob Potts. Other than that, the program is as scheduled. Secondly, we invite written questions from the registrants. All of the speakers will get together at lunch to discuss those questions, and if you wish, we will reconvene 15 minutes early at 1:15 to deal with some of the questions. I'm sorry we won't be able to entertain questions during the presentation of the papers because of time and because of the physical setup that we have here with 2 separate rooms and closed-circuit television. Furthermore, we have asked each of the speakers not to read their paper. That's an insult to everyone's intelligence, but to highlight the points in question and also to advise you of any recent developments in the law since the materials were published. And in addition, if possible, we will try during the afternoon to deal further with questions. Now, I would never have thought that mortgage remedies, and specifically power of sale and conveyancing, would be the subject of press coverage. However, some of you may have seen in the Ottawa scene of the Globe and Mail about 2.5 weeks ago a little write-up about the project and about the program. And this particular article just started off, and I'll only read the first sentence. You certainly can't accuse the Law Society of Upper Canada of being behind the times. And that certainly is the case. That article had many factual inaccuracies. What it was doing in the Ottawa scene, I still don't know to this day. However, I think that's the case. At 9:30, George Collins Williams is going to call upon Dr. Derek Mendes Da Costa to speak to you very briefly. This is at the request of Derek and for a very specific reason as to a project he is involved in. I think you'll find it of interest. Now, we're going to try to whip you in as to time and start as close to time as possible, and I hope you'll accept our apology if we do attempt to press you, but we have a very great deal to cover. I'll now call upon my associate and friend, Wayne Gray, who will have some more specific comments for you.
Thank you, Philip. Just a few comments about the program. Many of you attended the 1980 Mortgage Remedies Seminar, which dealt with power of sale and foreclosure. After that seminar got going, a lot of advice was received from lawyers both in Toronto and around the province to the effect that power of sale was really the mortgage remedy that people were most concerned about. And what we have endeavored to do is to design this program to meet the needs of the profession in a particular area where the law is just quite literally exploding. If you look at the All Canada Weekly series or the Ontario Reports, the number of cases coming out on mortgage law is just like an avalanche. And there's so much gray area that we felt it was important to put together a seminar that would somehow perhaps answer some of your questions and give you a little bit of guidance. Also, the questions that have been arising involving conveyancing problems connected with sales under power of sale, the two sections that we have given by Paul Mazza and Martin Stambler address themselves to some of the problems that real estate lawyers have been having in taking title and giving title under power of sale. Also, the program this year is designed to assist counsel who do work for mortgagors. Power of sale, not being a judicially controlled vehicle for the mortgagee exercising its rights, is one that has developed so quickly. There's so little law in many areas that mortgagors are sometimes left wondering what is happening to them, and then the sheriff shows up at the door. The papers have been prepared with a view to assisting defense counsel in advising mortgagors as what their rights and remedies are. And at the end of it, and specifically, we have a paper by Arthur Barat of Windsor, which deals with mortgagors' rights and remedies in great detail. I commend that paper to you. It's one of the best papers I've seen, and it's definitely important at a time when power of sale and foreclosure proceedings are escalating because of the high interest rates. Finally, one of the problem areas that was identified last year was, what about precedents? What are the affidavits supposed to look like? You'll find a precedent section in the back which we hope helps you when you have problems such as applications under Section 38 or Section 40 or dealing with the accounting of surplus to subsequent encumbrances. And finally, we never seem to be able to find that case that we've been talking about. You'll find an index in the back which lists all the cases, we hope, that appear in the materials. If there's any errors or typographical problems, I take the responsibility for that. I would note one. You might remember that the statutes in Ontario were just revised this year, and it happened after we got the material into the printers that a clerk in our office, or an articling student rather, discovered that the titles of acts in Ontario are now changed. We always had the word "the" with a capital T before the name of the act. Well, the commissioners who are responsible for revising the statutes each 10 years decided that we should be consistent with the federal government. And I have to advise you that you now do not put a capital T, you put a small t before the name of the act. And that you'll see that all through the citations that the capital T is there. I know it's of grave legal importance, and you were just dying to hear that one. I would like to ask Philip to introduce our first speaker, Martin Stambler. Thank you.
One thing I didn't say is we're going to try to keep the introductions as short as possible. Martin just said, give my year of the call to the bar, and that's all, but I'm going to tell you a tiny bit more. Martin practices in London. He is one of the deans of the practice in this area of mortgage remedies. He was called in 1959. He is the head of this program in London in January. He's been a special lecturer on choice of mortgage remedies in 1970. He's a senior instructor in creditors' rights in the bar admission course in London, and he has been frequently a lecturer and panelist on a number of continuing education programs on real property and mortgage remedies. And Martin is going to start us off, and the topic is power of sale, foreclosure, and judicial sale. Martin.
My remarks are somewhat of a further introduction to the a subject that we're going to be dealing with all day. Wayne Gray has sort of challenged me to review the whole area of foreclosure and power of sale, its advantages and disadvantages in 15 or 20 minutes, and I don't think I can meet that challenge. I have set out in the material a list of relative advantages and disadvantages. I'm sure some of you can add to that list. Those who don't like to read recitations, there's a nutshell summary at the very last page which gives it to you in one-page glance. So I could perhaps stop there and sit down. We're all familiar with the basic remedies, at least we should be, and my emphasis to you is to keep those basic remedies in the forefront of your minds when employing them either for the mortgagor or the mortgagee. Much of the difficulty in the area is and has resulted in a sort of a failure to keep in mind the basic consequences of these actions. We know that the basic remedy, the basic feature of foreclosure is the extinguishment of the mortgagor's equity, that the mortgagee accepts the property in satisfaction of the debt and is no longer accountable, can do what he wishes with the property, sell and make a profit, or if he sells and takes a loss, he assumes the loss. That is, one would say, it would be trite. We should know that. But it's interesting that since 1973, well, in 1973, the Supreme Court of Canada outlined those basic features, and since that time there have been 6 Court of Appeal decisions across Canada on essentially the same point. Things like if you sell a part of the property and foreclose on part of the property and then sell it, can you pursue a deficiency on the rest? Well, no, you've taken some of that property, you're no longer accountable, you can't sue for a deficiency. If you foreclose on on a collateral security, can you then pursue the deficiency on the primary security? If there's a promissory note and you foreclose, can you go against the note? And the answer consistently has been no. You have foreclosed, you've sold, you've accepted the property, there's no longer any deficiency. So the very basic tenets have really should be kept in mind. By contrast, of course, power of sale has that basic feature of accountability. Accountability on the one hand of the mortgagee to be responsible himself for the propriety of the sale and his proceedings, and the accountable for the surplus, and on the other hand, the mortgagor is accountable for the debt and the deficiency afterwards. Again, obvious, all known, but it's amazing that the number of questions that I think people practicing in this field consistently get that are related to that the basic thrust of those remedies. The choice has classically been between foreclosure on the one hand and sale on the other. And since 1964, when the amendments to the Mortgages Act came in to give a code of procedure which gave a sort of legitimacy to the power of sale. Mortgagees became comfortable with it and started using it frequently, and it became the sort of remedy of choice. With that, and I think mainly because of its speed and convenience. Once you choose the power of sale, then enters in the further decision of how you deal with the question of the payment with a writ and possession, so that there's the coordination of the payment and possession claim and when to do so. These are all judgment calls. And in order to make them intelligently, I certainly can't, I doubt whether any member on the panel can say, yes, here you choose power of sale, here you choose foreclosure. The mortgagee has got the prerogative to choose one or the other, and it is a judgment call. In order to make that call, you've got to know as much information as you can about the property, the security, estimated value, the strength of the covenantors, where is the most effective way to recover and which to go first. The concern is, and when Philip Spencer says give something that may be recent, well, I dropped in on the Canadian Bar Association meeting yesterday, and there was read out of one of the papers a quote from a decision which gave me some pause. Decision of Mr. Justice Goodman that says, a solicitor has the duty of warning a client of the risk involved in a course of action contemplated by the client or his solicitor on his behalf, and of exercising reasonable skill and care in advising him. If he fails to warn the client of the risk involved in the course of action, it appears probable that the client would not have taken the risk had he been so warned. The solicitor will be liable. If he fails to exercise reasonable care in advising the client with respect to his risk, and the client or solicitor on his behalf adopts a course of action which the client would probably not have taken or authorized if he had been properly advised, again, the solicitor will be liable if the client suffers a loss. A few years ago, I was asked, I think seriously, in a situation where a solicitor started a foreclosure action, and it got, as one says, a messy foreclosure action, and it took some 2 or 3 years to complete. Property had depreciated, and there was all kinds of collateral actions with it, and I think it was a resort property, and eventually there was a deterioration of the property, and the client suffered a severe loss. And the question was the lawyer and the solicitor negligent in not proceeding with power of sale? And I scratched my head at that time, and probably on the facts I was given, it probably was not. But in view of that kind of language that I just read to you, it kind of gives you pause. So but still, with the current rates running the interest, accruing interest, and the equity disappearing more quickly, the speed is the critical factor, and power of sale meets that demand. The 35-day non-extendable redemption period, after which the mortgagee is able to realize, is contrasted with this almost inevitably protracted foreclosure proceedings, where by a very simple DOR or DOS, 6 months is obtained, and you have to have appointments in Toronto with the master, and in most of the counties where there are no masters, you have to get appointments with the local judge, and a foreclosure action can take really upwards of, well, we've heard years. True, you can get a default judgment for immediate foreclosure within 15 days and accomplish that end. The speed of foreclosure really assumes, I think, two things. First of all, it really assumes, and it works best as an uncontested default procedure. It assumes that there is not going to be real challenge. Where there are serious issues as to accounts and priorities, serious issues as to or a concern as to a challenge being made, power sale may not be the appropriate remedy. It can't handle, as Wayne says, it doesn't have the procedure to handle the challenges. You have to go outside the procedure, which means motions or actions to determine rights. And the power sale just gets bogged down. You get a multiplicity, particularly if there's more than one competing claim. True, it puts all the defendants on the offensive. They must act. They must retain a solicitor. They must take the initiative. Whereas in foreclosure, it's so easy. There's a central forum, and they just get involved in interlocutory proceedings. It also assumes that the speed of the remedy assumes that the ease of the remedy assumes that the mortgagee is not going to be challenged on the conduct and the propriety, the sufficiency of the sale. And that's an important one. I must mention Arthur Barat and I have a case on right now. I don't want to give you all the details because we're just getting going on it. But I'll give you what happened. Basically, I acted for the owner and obtained an injunction stopping the sale just before it closed, on a power of sale, just before it closed. And Arthur acts for the purchaser. The mortgagee isn't here today. That was last August, a year ago August. We are just finishing the interlocutory proceedings. And that mortgagee is sitting there with a low rate of interest being stalled in his sale. And we don't know how long it's going to take, but I'll bet you that mortgagee wishes he never heard of power of sale. And that was challenged on a question of his conduct of the sale, an undervalue and whether he advertised it properly and so on. So that there are serious pitfalls and concerns with the speed of remedy. The second basic thing that the speed of the remedy assumes for its use and convenience is that you're going to be able to recover. It's very easy to say 35-day notice and we can sell. But if you can't sell, it doesn't really, the speed is lost. You're all familiar with a notice of sale that was issued, a year ago, and the mortgagee is still trying to sell. Well, in the time that has occurred, he could have foreclosed. You may have a prior mortgage that is coming up for renewal, and the mortgagee won't renew it unless the owner renews it. And you can't renew it if there are subsequent encumbrances. He doesn't want to increase the rate without having priority for that rate increase. So you have to have ownership to be able to deal with a prior mortgagee. Also, the nature of the property may be such that a long-term recovery is necessary, and you may have to have capital improvements and refinance for those capital improvements. And you can't do that unless you've got title. You can't, so that you need foreclosure and you need the title where you need capital improvements and or refinancing. Having said that, I still think that, and I think we've all concluded that power of sale is still the first choice of that remedy, of the remedies available. And, you may not need to proceed with the other actions unless, with foreclosure, unless you need, and this is the bottom line, and I've come to this conclusion that unless you can foresee serious issues as to priorities and you can read a possible challenge from the mortgagor, then you'll be going by way of power of sale. If you see those foreseeable issues and you need either refinancing or capital improvements to eventually recovery, for eventual satisfactory recovery, then really power of sale may not be the appropriate remedy. the afterthought, which I perhaps will toss in, and it may not be, if I've got time, I've got another 2 or 3 minutes. The other question, which I'll mention now, rather than later in the conduct of sale, because there's so much to deal with in that area, is the question as to whether you can accomplish the extinguishment of title and get an effective foreclosure by selling to yourself. That's often asked. Can we sell it to whoever? If there's one rule about power of sale that is really very, very clear, is that you can't sell to yourself. It is not a sale. And not being a sale, you don't even consider whether it's a good sale. So it ends right there. I don't care how much you sell it for, whether the mortgagor is given credit for the full appraised value of the property, it's no sale. Then the corollary of that is, well, can you sell it to a trustee? Can you sell it to an agent? And the answer again is no. The corollary is, if you can't sell it to yourself, you cannot sell it to a trustee for yourself. Beyond that, there is some jurisprudence around that said that if you sell it to an associated company, or if you sell it to a party in which the mortgagee has an interest, then that appears to be acceptable. But the propriety, then the onus is on the mortgagee to show the propriety of the sale, and the onus is on him. Usually the onus is on the mortgagor to attack the sale and to say that there was lack of propriety. Where the mortgagee sells, and the case on that is I deal with that in the material on the conduct of sale, but I thought I just mention it now in terms of extinguishment of title. The old case of Farrar and Farrars was one where a mortgagee sold to a company. In fact, the mortgagee was a solicitor, and they couldn't sell the property. They tried, and they eventually sold it. He promoted a company to buy the property, and the mortgagee took an interest in that company. And the corporate veil was held up, and the propriety of the sale was not challenged in terms of the amount, and the sale was held to be a valid exercise of power of sale and not set aside under the rule that you can't sell to yourself. There's been few recent decisions along that line, but nothing coming really clearly to satisfy us that you can sell to say, a company of which you are the sole proprietor, as a sole shareholder and officer and director. That hasn't been held yet, and I'd be a little hesitant about that one, but it's a gray area. Certainly you can sell. There's been a sale to your brother, a sale to a wife. That has been upheld. So that if there was a bona fide sale and the mortgagor gets full credit, or the propriety can be established, that kind of sale could be upheld and can be a way of quickly extinguishing title. I'll deal with the conduct of the sale later this afternoon, and I think we can now, I think I've used my time, and I'll leave what I'll say when the last judgment call is, once you choose power of sale, the judgment call then becomes the question of the claim for payment and possession, when and how. And I think some of our other members are going to be dealing with that judgment call. Thank you.
Thank you very much, Martin. George?
Ladies and gentlemen, we are going to have just about 4 minutes of something that is not on your program. We have with us Dr. Derek Mendes Da Costa and Professor Barry J. Reiter. I know that most of you, all of you, know Dr. Mendes Da Costa as the chairman of the Ontario Law Reform Commission, and many of you will have studied under him either at the University of Toronto Law School or at the law school at York University, Osgoode Hall Law School of York University. Professor Reiter, many of you will know, is a teacher and law professor at the University of Toronto. Now, their roles here this morning are to speak to you as a kind of a captive audience of the part of the bar most interested in mortgages, because the Law Reform Commission is undertaking a Law of Mortgages project. And I know that Dr. Mendes Da Costa is going to invite some input from you. Barry Reiter is the director of that Law of Mortgages project. So with that, I'm going to ask Dr. Mendes Da Costa to say some words.
George, thank you very much indeed for the courtesy to permit me a few brief moments to make an announcement to this meeting. Thank you for the courtesy, George, and thank the Law Society of Upper Canada, too. Much obliged to you for this chance to bring to the attention of the meeting the Law of Mortgages project of the Ontario Law Reform Commission. In the view of the Commission, this is an important and significant project. It's one that's very much practice-oriented. And during the course of the project, the Commission would much appreciate the cooperation and participation of the practicing profession. Now, the program here today, Mortgage Rights and Remedies, seem to me to be an ideal opportunity to make this announcement. You're dealing now with problems in the area of mortgage law, where the Ontario Law Reform Commission would deeply appreciate your assistance in our research and your input into our project. What, in your view, are the problems in the law of mortgages? What, in your view, are areas of the law that should be reformed? We hope eventually, obviously, to report. We hope our report is implemented. If it is implemented, perhaps it will change considerably the present law and practice of mortgages. So at this stage, we most earnestly ask for your cooperation. What we do plan is a complete an entire study of the law and practice of mortgages in the province. Now, the project director, our project director, I'm delighted to tell you, is Professor Reiter of the Faculty of Law of the University of Toronto. And what I would now ask your indulgence, please, is to receive Professor Reiter again for a few brief moments to indicate to you the scope of the research. Barry, could you?
Thanks, Derek. I'll be exceptionally brief. I appreciate you have enough problems today and enough to do today trying to figure out the existing remedies and problems with that. All I wanted to do this morning is just introduce myself to you and introduce the project to you. Tell you what we're trying to do is to make the next session of this program that occurs a few years down the line a much easier one. The only way we can do that is really to get your help throughout the project, and particularly at two stages of it. The first stage, and in a sense the most important one, is the one we're at right now, which is trying to identify problems that we ought to address, we the the Law of Mortgages project ought to look at. We've written to the Canadian Bar Association and various committees of that and other associations of lawyers. But what I'd like to do today is appeal to all of you directly as people who are involved in these things, as people who see problems from day to day that might not come to our attention. At any time in the near future, please get in touch with me or with me through the Commission and advise me of things you think we ought to be looking at, of problems you see in practice that you think the Commission ought to be looking at. Either problems of remedies or any other problems in the law of mortgages that arise either from your view as practitioners or as surrogates for mortgagors and mortgagees who we may not be able to touch base with as well as we can with you. At a later stage in the project, we will also be asking for your assistance again in trying to evaluate various responses to the problems we have, problems we've identified and things we're going to look at. What I'd like to do today is just leave for you, and I'll leave them up here, please feel free to pick them up, a description of how the project will proceed over the next couple of years. And I'll leave you just by saying again, we are anxious, we are in need of your help to make this thing work. It is for the benefit of everybody to do so, and we really do invite your assistance. Thanks very much.
I would only say that with this caveat that the report of the Law Reform Commission will result in a new act which will give us more business. Now it's my particular pleasure to call upon Carol Mcpherson. She's the last member practicing in mortgage remedies at Staples and Sewell who will be thrust upon you. But why it's a particular pleasure is not only she's a very fine person and a charming lady, but she was the planning assistant and the person who did what you can best term the dog work in this program. I don't think her contribution can ever be adequately acknowledged, including proofreading, assembling, and initially getting the materials in which are in the bound volume, which was ready over a week ago, which is an amazing development for us or anybody else in these programs. Carol was called to the bar in 1979. She was a small partner, partner in a small partner too. I went to bed too late last night. She was a partner in a small law firm in Streetsville and then saw the light and accepted our offer to come and join us. She practices exclusively in mortgage remedies with Wayne Whizzer Gray, who sits to my right. And she is going to speak to you today on preliminary procedures. Carol?
Thank you, Philip. You're deserting me today. Most of today's seminar is going to deal with the technical aspects of exercising power of sale. And once the power of sale has been completed, conveyancing of property that has been subject of the exercise of a power of sale. I'm going to speak to you in a general way about preliminary procedures that should be undertaken in most cases before we get into the more complicated procedures that have to do with power of sale proceedings. I say they should be undertaken in most cases because there are certain situations where there's just no point in doing a preliminary collection because the property's being vacated or there's some other information that you know there's no possibility of the mortgage being brought into good standing. But in most cases, there are certain things that should be done before getting into power of sale. I don't know how many of you deal with institutional lenders and how many with private mortgagees. The basic procedures are the same. There are a few differences that have to do with the expectations that a mortgagee may have on the solicitor. But I'll go through the general things that should be done in most cases. Institutional mortgagees pretty well always have an internal administrative procedures to do with how much arrears will be tolerated before collection letters are sent out. They have their own internal procedures to do with telephone calls, personal contact, form letters, once a mortgage is in arrears, probably for 1 month, maybe 2. then there's some sort of decision about when to send a file on to a solicitor for further action. In my experience, most mortgagees send along a copy of the mortgage document along with some sort of form that indicates, the basic information a solicitor needs to start acting. This would involve, the name of the mortgagor, obviously, the address of the property, the fact of default, and detailing how much of default there is. If the mortgage is insured by one of the mortgage insurers, and a very helpful thing to have from an institutional lender is what is going on before in the lender's shop, to find out how much contact there's been, if there's a particular story already that the mortgagor has about why there's default. Because when you get phone calls in your office from the mortgagors about, I didn't understand, I didn't know, you have something before you that shows that there was prior contact with the mortgagee. In the precedent section, I've set out a demand letter that could be used by a solicitor once the file has reached the solicitor's office. The precedent letter is based on the information that's received by the mortgagee. It sets out the obvious things like the capacity of the solicitor, the fact of default, details the default, and indicates what's going to happen if the default isn't cured. It also gives a basic period of time in which to cure the default. There's one question about where to send a demand letter. In most cases, it's going to be pretty simple. It's going to be the address of the mortgage property. However, there may be some information in the mortgagee's file that indicates the mortgagor is not living on the property, he's rented it out. You'd like to think that mortgagees always send you this information so that you can send 2 letters out and try to contact the mortgagor. Sometimes you find it doesn't happen that way, and you get phone calls about 6-7 days later saying, I don't live there anymore, I didn't know, my tenants didn't send me the letter. At that point, you just have to make a decision about what further action you're going to take. There's a recent case of Royal Trust Corporation in Doyle, which indicates it's the responsibility of the mortgagor to keep the mortgagee informed about changes in address. In that case, it was actually a notice of power of sale had gone out to the security address. Quite clearly, the tenants of the mortgagor had not forwarded on the demand letters or the notice of sale. And the mortgagor came along and said, I didn't understand, I didn't know about it, and didn't want to pay all the extra costs. And the court felt that, it was up to the mortgagor to keep the mortgagee informed, and the mortgagor had to pay the extra costs. The court, in the Royal Trust Corporation in Doyle case, distinguished the case of Rehal Wright Motors and Industrial Development Bank, which is again a case of a notice of sale going out to simply the security address. But in that case, the mortgagee had had a lengthy correspondence with the mortgagor and knew perfectly well that the mortgagor wasn't living there. In that case, they had to start all over again. So in most cases, you can be pretty sure that just sending it to the security address is all you have to do. It's only if you know that there's some other address to which it would be advisable to send a duplicate letter. Our precedent letter sends out a expiry date of 10 days. We found that generally is an adequate time given the realities of the Postal Service. What the problem is not giving enough time for the mortgagor to respond is that the next step generally is to get instructions from a client to take further legal action. This has to do with carrying out title searches, carrying out perhaps searches for tax arrears, condominium arrears, preparing notice of sale, all of which cost money and cost time. And if the mortgagor comes along the day after the expiry date and says, I just got the letter yesterday, I was away for 2 days, it's going to be pretty difficult to collect all the extra costs. Basically, if you have some information in the file that indicates the mortgagor has never been in arrears before, it's a one-shot time, and there just is a reasonable explanation, it's usually a good idea to give them extra time. If, on the other hand, the mortgagor has been in default constantly and really knows the score and is just trying to stall for time, keep very rigidly to the expiry time. There's also an indication on the demand letter that partial payments will not be accepted. This is based on the decision in Rebodiak and Collison. although it's obiter in that decision, there's some indication that accepting partial payments will lead to a new payment schedule being set up, and if further proceedings have to be taken, a mortgagee will have to start all over again. When you're just at the preliminary stage of a demand letter, often a mortgagee will make a policy decision to accept partial payments. They, particularly if they've had some personal contact with the mortgagor, there's a legitimate hard luck story. The mortgagor is very positive that he'll be able to bring the mortgage into good standing. The mortgagee may make a decision to accept a partial payment or accept a new payment plan, and that, of course, is up to the client. Our advice would be not to generally get into that kind of thing because in many cases the mortgagor just can't keep up the payments. But that's a matter of getting instructions. I would submit the basic difference with a private mortgagee is that there may be some expectation on the solicitor to devise the mortgage account themselves. Private mortgagees perhaps may not quite have adequate records about how many payments are in arrears, particularly if they're quarterly plus interest. They may have forgotten one payment that didn't come in. And you may be faced with a pile of documents and papers and you have to work out the mortgage account yourself. The other suggestion I would make if you're dealing with a private mortgagee, particularly if it's a vendor take-back situation and you've acted on the transaction, you're aware that there's a solicitor involved with the mortgagor, it might be a good idea to contact that solicitor, see if something can be worked out, because the mortgagor may not be aware of the situation. The second kind of demand letter that would be sent out in some cases is where there are subsequent encumbrances. Sometimes you'll know that from the mortgagee, particularly if the file has already been in arrears, you'll know that there's a second mortgagee or a mechanics lien claimant or whatever. But if you don't have that information from a mortgagee, you'd have to do a title search to get that information, and that, of course, costs extra money. The problem with not contacting a subsequent mortgagee or a subsequent encumbrancer is that often the mortgagee will come along once the power of sale has gone out and said, I didn't know about it. If I'd known there was arrears, I would have brought the mortgage into good standing. So it could be a judgment call in each case about whether to go ahead, spend another 10 days of delay in contacting the subsequent mortgagee. It would depend on the amount of the subsequent encumbrance, again, the history of the file, and instructions from the client. Further precedents in the demand letter, further precedent of demand letters is one for default in payment of taxes. The decision of Reboyer and Fox was a situation where a notice of sale went out when the mortgagor was not in arrears for the mortgage, was only in arrears for non-payment of taxes for, I believe, 2 years. The mortgagor had been contacted orally to pay the taxes, but had never been given a written demand, and the mortgagee hadn't paid the taxes directly. The court felt that the mortgagee could have paid the taxes and added the amount to the mortgage account and then taken proceedings, or should have at least made a written demand, given the mortgagor 15 days to bring the mortgage into good standing, and then that would trigger the timing for sending out a notice of sale. So in cases where there are default in taxes, the demand letter shows some form of a letter that could be sent out to trigger the default timing. Secondly, there's a letter concerning a breach of covenant. This one is an example of breach of covenant to commit waste. There's a case, Reshift, Gross, and Ferrara, that with that particular situation, a house was being demolished by the mortgagor. He appealed to the mortgagee prior to get permission. The mortgagee said no, and the mortgagor went ahead and tore it down anyway. At that point, the mortgagee brought proceedings on the basis of the breach of covenant. And the court held that it was incumbent upon the mortgagee to make a demand in writing to the mortgagor before instituting legal action so that the mortgagor would be given 15 days and then the notice of sale could go out. I'd like to deal briefly, this particularly deals with institutional lenders, or I guess exclusively actually, with the requirements of the mortgage insurers, sorry. CMHC, in its lender's handbook, doesn't specify what proceedings should be taken prior to legal action being commenced. but it indicates that if there are arrears on a mortgage, the lenders are expected to report these monthly and indicate what collection procedures have been taken out and what legal proceedings have been taken out, along with the dates that proceedings have been taken. There's also an indication in the regulations that if CMHC is not satisfied with the proceedings that have been taken, they will indicate that to the lender. And if they're not satisfied that things didn't move along fast enough, there may be a penalty in not collecting enough interest on the insured loan. MICC, on the other hand, sets out about 2-3 pages of suggested collection proceedings that should be undertaken before the file is referred to a solicitor. They go on a bit about, they recognize that there are frequently different procedures that each bank or trust company or whatever carries out, and they don't say that they have to undertake these proceedings, but they say, quote, MICC will not be liable for amounts claimed which might reasonably have been avoided had one or another of the steps outlined or a suitable alternative been followed. And that seems a fairly clear threat that if the lender does not, do some sort of fairly rigid collection proceedings, they set out a 10-day step, a 20-day step, a 1-month step, a 2-month step, there will be some penalizing of the lender in collecting on the loan. Again, Innsmore insurer doesn't set out a particular recommended steps, but they say that there should be a regular collection proceeding and that the lender should maintain surveillance over the performance of solicitors to avoid any loss of time. Innsmore and MICC have recently become amalgamated, although they're maintaining their separate entities for the time being. I would suggest that with Innsmore insured loans, there may be some indication that the stricter standards of MICC should be followed probably quite immediately. Finally, the paper deals briefly with Section 21 and 22 of the Mortgages Act. Section 21 is a remedy for a mortgagor. The mortgagor, before legal action is commenced, can pay up all the arrears and any expenses necessarily incurred by the mortgagee. Then they're relieved from the consequences of default. The demand letter, which is being sent out by a solicitor, would speed up this process. The mortgagor would have right in front of them exactly what's required to bring the mortgage into good standing, the amount of the arrears, the amount of taxes paid or whatever, the late interest if charged, the costs. And it's just a matter of paying that and everything's back to normal. The second thing that Section 21 does is provide that a mortgagor may demand in writing a statement from the mortgagee as to the amount of the arrears and the nature of the default if it's a breach of covenant that has caused the mortgage to go into default. And the mortgagee has to provide this statement within 15 days of the notice by the mortgagor. Hopefully the demand letter that's gone out by the mortgagee solicitor will have provided adequate information in a very straightforward manner that this kind of demand could already have been met by the demand letter. In conclusion, I'd just like to say that the goal of most mortgagors and mortgagees is to keep their mortgages in good standing, I would think. Most mortgagors just want to pay their monthly payments and pay off their mortgage when it becomes due, and mortgagees want to keep their loan portfolio in healthy shape. In most cases, prompt and effective action in taking preliminary collection procedures will affect the goal of keeping the mortgage in good standing without the necessity of the more complicated legal actions which will be discussed this morning and this afternoon. Most mortgagees, I wouldn't think, want to get involved in appraisals and listings and mortgage insurance and all the other things that go along with power of sale and then conveyancing under power of sale. Certainly you may be doing a mortgagor a favor by prodding them into action before the matter gets any worse. Thank you.